Welcome back, everyone. And buckle in, because today's case is a roller coaster inside a Texas courtroom. From the very first seconds, the tension is thick. We've got defendant Dalius Williams, a man on unadjudicated probation, facing a motion to revoke. But the plot twist? There's now a new allegation on the table, and this new charge completely wipes out the original plea agreement he thought he had locked in. Right away, the judge makes it clear. That deal, gone. Why? Because Mr. Williams' probation violations might not just be technical. They could involve evading arrest, and worse, a new charge of injury to a child. This isn't just a standard probation hearing. This is a man who has to decide, on the spot, whether to stick with the pleas he previously gave, or rip them up and start fresh under far harsher conditions. We're talking years of prison time potentially stacking on top of each other. And if that wasn't enough, the judge needs to swear him in immediately, meaning every word he says from here on out becomes sworn testimony. No room for misunderstandings. No room for backpedaling. As we dive into this transcript, watch how the judge navigates confusion, changing pleas, unprepared witnesses, and rising stakes, all while trying to determine whether Mr. Williams deserves one final chance, or whether the safety of children and the community overrides everything else. Before we go deeper, let me ask you, if someone repeatedly violates probation and racks up new charges, should judges continue giving second chances? Or is there a point where the system has to cut ties? Drop your thoughts in the comments, and because this case is a prime example of that tough question. All right, let's get into the moment where everything shifts.
We're here in cause number 1932623, and we have had some discussions in the back that I think we need to put on the record with regard to the case and where we are. We have, first of all, sir, you're Dalius Williams, and Mr. Williams is here with Mr. Rojas. Mr. Smith is here on behalf of the state. There is a second amended motion to revoke unadjudicated probation. So because the new allegation, I'm not going to accept the plea agreement of the cap of 4 years because there's a new. So I will allow, if Mr. Williams wants to withdraw his pleas of true to 1, 2, and 3. I can go through those again and get pleas today on those, and then we can go forward with what we have today. And then if I feel like there needs to, it's my understanding, Mr. Smith, for today, you have witnesses with regard to proving up count 4 only. Is that correct?
That's correct.
So what we can do today, depending on what those pleas are, either way, we'll go forward with what we have because there's witnesses here. And then if I feel like I need to postpone the hearing to another date for the state to prove up more, then we can do that then. So, Mr. Williams, the best you can, I need you to raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can put your hand down. And so, Mr. Rojas, what is y'all's position?
Judge, I think after discussions with Mr. Williams, I think he would like to withdraw his plea of true to count number 3.
Okay. So just to go back, count 1, Mr. Williams alleges that you violated your probation by failing to report to the probation department October 25th and December 15th of 2022. You had previously pled true that was true. And do you want to continue to plead true to that count? Okay. And then count 2 alleges that you're behind in your court-assessed fees as of January 4th of 2023 in the amount of $3,638. You previously pled true to that count. And do you want to continue with your plea of true to count 2? Count 3, which was in the added in the first amended motion, alleges that you committed the offense of evading arrest or detention July 14th of 2024. You had previously pled true to that count, and do you want to change your plea of true in that count? You want to change your plea to not true? Okay, so we'll enter a plea of not true to that count. And Mr. Smith, I know you weren't prepared, I guess, for that, but have y'all had any contact with the officer? I would think that would be a one witness.
It's actually several witnesses, Judge.
Okay.
they're going to serve a warrant at his house. There were 2 officers in the back that see him come out of the back of the house.
This is a critical turning point in the hearing. Notice how the judge pauses and says, "We'll see where we get today then." That's courtroom speak for, things just got a lot more complicated. Mr. Williams has just changed his plea on a major violation, count 3, from true to not true, which means the state now has to prove it. But here's the kicker. The prosecutor wasn't prepared for that sudden change. He expected 1 officer. Turns out they actually needed multiple officers because of the alleged evading happened during a warrant service with multiple witnesses. That instantly shifts the courtroom energy. This kind of move can backfire for defendants, because judges may feel the defense is playing tactical games or wasting court resources. Still, it's his legal right to challenge the allegation. What do you think? Was this a smart strategy or a risky delay tactic?
Okay.
Knocking on the front door, so we need both of them.
Okay. Okay. All right. So we'll see where we get today then. Mr. Williams is on probation for possession of a controlled substance, and that, which was a 3rd-degree felony, correct? No. That's
Yes,
been, oh, it was as well. I've got the indictment pulled up from the injury to a child. That's a 3rd-degree felony. But that possession of a controlled substance is a 3rd degree as well. So the range of punishment is between 2 years and 10 years. And Mr. Williams, I also want to make sure you understand that if we go forward with this motion, and I do end up revoking your probation, then later, if the state does prove, so we have the injury to a child, that new case, if you're found guilty in that new case, then the punishment could be stacked. Do you understand?
We need to pause here because the judge is laying out something incredibly serious: stacking sentences. For those unfamiliar, stacking means that if he loses the new injury to a child case, the prison time from that case wouldn't run at the same time as this one. It would start after he finishes the first sentence. This is massive. Instead of 4 years, he could suddenly be staring down 8, 12, even 20 years depending on outcomes. And the judge stresses that it's her choice whether sentences stack, not a jury's. This is where defendants often crumble under the pressure. One wrong move, one guilty verdict, and life changes dramatically. Let me ask you, if you were facing the possibility of stacked sentences, would you take the plea or roll the dice at trial?
Do you understand that? Okay. Mr. Rojas, you've gone over all of that with him, correct? And it's also my understanding that y'all had, even in the back, Mr. Williams' mom in the back to go through everything, what his options were, and all of that this morning. Is that correct as well?
That's correct, Your Honor.
Okay. What if any offers? I want to make sure Mr. Williams, on the record, rejects anything that's been offered.
We had offered 4 years in this case, Judge, and he is rejecting that offer.
Did that include an offer in the injury to a child?
Actually, I offered 4 years in both cases to run concurrently.
Okay.
If he went today.
Okay.
He said no. And I told him that if he didn't do that, if we go to trial on the new one, I would move to stack that case on whatever he gets in this case, and the 4 is off the table on this case.
Okay.
I apologize, Judge, and I didn't hear what the last part. Did Mr. Smith talk about the 4-year offer for today to the possession of a controlled substance? And if he were to be tried in the future, if he were to be convicted for the injury to a child, that case would be stacked? Did you say that?
He would request it, and it's up to me. So anytime the state asks for a case to be stacked, it's up to the court to do that. So it's not up to a jury. If you go to a jury trial on that injury to a child, what would happen? Let's say you go forward today, we have this hearing. If I revoke your probation and give you any time in prison, then the next step would be to set that injury to a child for a trial. And then if you're found guilty in that case by a jury, then what the state is saying is that they would ask me then to stack that, whatever sentence you might get, if you get a sentence, on top of what happens today in the motion to revoke probation.
At this point, the judge has repeated the options multiple times, and that's intentional. Judges are legally required to ensure defendants fully understand the consequences of their decisions. and Mr. Williams seems hesitant, confused, or overwhelmed. We also learn that his mother was brought in the back to help him understand the stakes. That says a lot. When family gets involved behind the scenes, it usually means the defendant isn't fully grasping how severe the situation is. The judge is essentially saying, whatever happens after today, you can't come back later and claim you didn't know. This moment is where the courtroom tension shifts from procedural to emotional, because it shows just how heavily this decision weighs on everyone involved. Would you say the judge is being patient here, or firm, or both?
Do you understand? Okay. And so your options are today, if you wanted to go forward with a plea in both of your cases, plea of true in that motion to revoke for a 4-year sentence, plea of guilty in the new injury to a child case for a 4-year sentence, with the agreement that those sentences would run at the same time. You don't have to do that. We've got witnesses here. We'll go forward with the hearing. Just want to make sure you understand what your options are today that you won't have after today, and what your consequences could be if you go to trial and if we go forward. And nobody's trying to talk you into anything. I just want to make sure you understand it all. Does that make sense? Okay, so you understand everything that's been offered and what what you could do today and kind of where we're about to go, right? And so what do you want to do?
True to first, but not to the injury to the child.
Okay, then we'll go forward with this hearing. So I want to make sure also for the record what all I've reviewed. The original PSI, obviously from being placed on probation, is included with the updated pre-sentence report. Everyone should have that as well. And so when I went back through that, I just want to make sure that there aren't any corrections or issues with regard to that criminal history specifically that I'm looking at. It starts on page 1 and then carries on to page 2 on that pre-sentence, or actually it was a post-sentence investigation, I think. Y'all have that? Everybody's on the same page as me?
Yes, ma'am.
So it looks like there was adult misdemeanor history of 2 thefts back in 2013. Both of those were 30 days in jail. There was a theft of services in 2014 where Mr. Williams received a probation. That probation was revoked in 2016. That's in Rusk County. Possession of marijuana in 2014, Nacogdoches, 3 months in jail. A resisting arrest or search, March of 2015, where there was a probation given that was revoked in 2018. There was then a 2015 failure to appear bail jumping case in Nacogdoches. 2016, burglary of a vehicle, 30 days jail, and then 2019, a resisting arrest again and an evading arrest also in 2019, both with 180 days in jail. Then the felony criminal history I show is a criminally negligent homicide from 2017, where a probation was given in 2018. That probation was revoked in 2020. Looks like that probation was revoked based on, and looking back on all of this, I'm not real sure other than what we were all thinking, but it looks like on January 10th of 2020, the probation was revoked on the criminally negligent homicide. There was a new offense of injury to a child that he appears to have pled guilty on and received a 12-month state jail sentence. There was another offense, new offense, from January of 2019, an attempt to take an officer's weapon, also same disposition date of January 10th of 2020 for the 12 months in the state jail. And then there was this possession case that we're here from that same date. So it looks like he took some time on a couple of things and then got probation on the possession. Does that, everybody On the same page as that?
Yes, Your Honor.
I did look back. I think because I have this information, I don't think it's necessarily improper for me to look at some of the information based on those cases. I do have a question specifically with regard to the injury to a child from 2020 that he pled guilty on. What is the relationship with, that was the victim in that offense?
It's the stepson, Your Honor.
So Ms. Broussard has.
This section is absolutely loaded. The judge walks through Mr. Williams' entire criminal history, and it's long, detailed, and deeply concerning. You can feel the escalation, from thefts, to resisting arrest, to evading, to criminally negligent homicide. And now another allegation of injury to a child. Most judges don't take the time to outline someone's full record unless they're building toward a major point, a pattern of behavior. She's showing that every chance he was given in probation, reduced charges, alternative sentencing, ended the same way. More violations, more arrests, more violence. When a defendant has multiple revoked probations, courts lose confidence that future supervision will succeed. And that's exactly what's happening here. Do you think a record like this should automatically disqualify someone from getting another chance? Or should every case still be decided individually?
Other children.
Yes.
That are not from Mr. Williams.
At least one, Your Honor, yes.
So when we went back through, Mr. Williams entered pleas of true to counts 1 and 2. So I am going to find, based on those pleas, counts 1 and 2 true. Count 3 entered a plea of not true, as well as on count 4. I am going to find, based on the evidence presented today with regard to count 4, that there is sufficient evidence to find count 4 true, and at this time I am going to find count 4 true. I understand everyone's position. I think with regard to there'd be different evidence, I would think, and probably more potentially at a trial. I'm not required to look at all that, and obviously the level of the burden is different. So count 4 is true.
We've now reached the sentencing arguments, and both sides come in strong. The defense tries to highlight practical issues. Mr. Williams can't bond out, he can't be placed in certain probation programs because of pending charges, and they argue for leniency. Meanwhile, the state hits hard, saying he's shown a clear inability to complete probation and pointing out prior convictions involving children. This is where the courtroom becomes less about facts and more about persuasion. What's the safest option? What protects the public? What holds the defendant accountable? Both sides are fighting the narrative battle, and the judge is about to make her stance incredibly clear. What would you argue if you were the defense attorney here? Could you make a stronger case for probation, or is that ship already sunk?
Mr. Rojas, you may proceed with argument.
Judge, when we did the initial plea, we got the updated PSI report, and they were recommending that if probation were to be granted of ISF. Obviously, that can't happen with a new charge pending. He does have this new injury to a child that after speaking with the family, I don't think he's going to be able to bond out even if you were to keep him on probation. If the court is inclined to keep him on probation without ISF, we ask you to do that. If that's not going to be possible, Judge, we ask the court to consider something in the range for the possession case, 2 to 4 years.
All right. Thank you, Mr. Rojas.
Judge,
Mr.
I
Smith?
believe his criminal history shows fairly convincingly that he is unable to successfully complete probation. Speaking of probation officer, I don't believe it's their desire to keep him on probation with this type of charge pending, especially in light of the fact that he's already been convicted of injury to a child within the last few years. That tends to me to show more than just a pattern, it's a habit. The fact that he doesn't respect authority is shown by the jail incident reports. I feel like he needs to be revoked in this particular case, and we're asking for no less than 5 years, somewhere between 5 and 10 years as punishment in this particular possession.
Thank you. And also, just for the record, everybody has those jail incident reports. Those were provided. I've reviewed those as well. Mr. Barksdale's here. Mr. Barksdale, the probation officer, do you have anything to add at this point with regard to your position?
No, ma'am, I concur with the district attorney.
Okay. Thank you, sir. Mr. Rojas, I would give you an opportunity if you want to. We can ask Mr. Barksdale to come if you have any questions of him.
No, Judge.
Okay. And Mr. Williams, you're 30 years old? You just turned 31. So I appreciate that you have support here and people here to support you, but your behavior to me tells me that you shouldn't be around any children, much less your own. Whatever is happening with you when you're getting angry at these children with what you're doing, because it's the same. This appears to be the exact same type of incident that you pled guilty for a few years ago when I put you on the probation for the possession. And this, it's ridiculous. You and Ashley both don't need to be around.
This is the emotional peak of the entire hearing. The judge drops all formal distance and speaks from the gut, and she is furious. When a judge openly says a defendant shouldn't be around children, it means the evidence and history paint a devastating picture. She mentions the marks on a 2-year-old's back, not scratches, not minor injuries, and draws a direct connection to past behavior he was already convicted of. This is extremely rare judicial language, blunt, personal, protective. You can feel the weight of the judge's responsibility. These are the moments where the court's duty to children and public safety overshadows sympathy or second chances. Let me ask you, do you think the judge's emotional reaction is justified here? Or should judges remain more neutral, even in cases involving children?
Any children. Don't need to be having more children. You can't take care of your own children. And you're disciplining them by doing this. And I don't think there's any reason for anybody to believe that no one said these are scratches. That's not what the doctor said. If there are, they're adjacent to these other marks on the back of this 2-year-old. Going to find, again, that you entered your plea of true to counts 1 and 2, freely and voluntarily. Find those counts true. Find count 4 true. Find sufficient evidence at this time to find you guilty of possession of a controlled substance. I'm going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I'm making a notation on this because originally it was a plea agreement that when it was signed. I'm making a modification. Let me change it. This was not a plea agreement, so you do have some rights to appeal. I'm also going to hand you a written admonishment regarding, hold on a second, regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Rojas. Thank you all. I'm sorry. I know this is difficult for everyone, but I have no doubt in my mind that Mr. Williams, not just on this occasion, but probably on many, has obviously improperly disciplined, if that's what you want to call it, all of these children. So, court is adjourned.
All right.
And with that, the judge makes her final ruling. 8 years in the Texas Department of Corrections for the possession case, based on the true findings in counts 1, 2, and 4. She also reminds Mr. Williams that he is now legally prohibited from owning firearms, a standard but important part of felony sentencing. What makes this case especially significant is the judge's reasoning. The pattern of probation violations, the concern for child safety, the repeated criminal behavior, and the overwhelming belief that continued supervision simply would not protect the public. This wasn't a snap decision, it was the culmination of years of documented conduct. Whether you agree with the outcome or not, this hearing highlights the difficult balance courts face between rehabilitation and public safety. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.